Okay, we're ready to call to order the Area Plan Commission Tippecanoe County Executive Committee meeting for November 6th, 2024. First on the agenda is approval of minutes.
And we'll want to get our roll call, too.
That's what I said. First on the agenda is a roll call. Sorry.
Larry Leverance.
Here.
Gary Schroeder.
Here.
Jerry Reynolds. Jerry Reynolds. Greg Jones.
Here.
Tom Murtaugh.
Present.
Jackson Bogan. Jackson Bogan. Kathy Parker.
Here.
Quorum present.
Thank you. Now, briefing session.
Let's see, I believe we've got a continuances on the subdivision, so our FDP is ready to go.
Very good. Thank you. Next.
S5205.
One continuance, one withdraw. Trying to read through that screen. One continuance, please.
Okay, and one withdrawal. Thank you, Kathy. About next, approval of the minutes.
I move to approve the minutes from the October 2nd, 2024 public hearing as submitted.
A second.
So I have a motion and a second. Any comments or corrections? Hearing none, all those in favor say aye.
Aye.
Opposed? That motion carries. New business.
I move to hear and vote on Resolution PD 2411.
A second.
Okay, well, at long last, this project is wrapping itself up. They've actually had bonding in place for a month, but they've been working through some final plat issues, mostly because this is a very significant step in the conversion of the levee into more of an orderly street grid, and this project's delivering the first installment. So there's our existing conditions and the project area. And then the proposed conditions, realignment of Howard Avenue, so it's no longer coming in at a strange angle. The creation of a new road to intersect with Brown. And Brown Street is being truncated for this project and partially vacated, but then the remainder is going to be where it is. So construction plans have been approved and recorded for a year, and to my knowledge, all that's happened out there is people have been, taken out of their restaurants. Their leases have been concluded and they're out. I believe everyone's out at this point. So, but they've not really begun any site work as far as I can tell. So it's possible they may have wanted to wait till this stage, but regardless, here we are. So everything is in order relative to the final plat and the UZO. Again, bonding is being requested and has already been submitted and accepted. So we are recommending approval of this resolution. Happy to answer any questions.
Very good. Thank you, Ryan. Anybody in the audience wish to comment on this? Questions or comments from the board? Hearing none, we have a yellow ballot.
We have a unanimous ballot for approval.
Very good, thank you. Now, part of our public hearing, we did have, as Kathy mentioned, S5205 Baines Minor Subdivision has been withdrawn. So next, we're going to take the continuance, Larry, please.
I move to continue S5218 HMS Rentals, formerly Snyder, minor subdivision, a replat of Bartholomew and Davis Lot 49 minor sketch to the December 4th, 2024 Executive Committee hearing so the required Lafayette BZA case can be decided.
A second.
All those in favor say aye.
Aye.
Opposed? That motion carries. Approval of the November APC public hearing agenda.
I move to place USO Amendment number 14 on the November 20th, 2024 Area Plan Commission public hearing agenda.
A second.
All those in favor say aye.
Aye.
Opposed? That motion carries. Larry.
I move that the following subdivision petitions be placed on the November 20th Area Plan Commission public hearing agenda at the petitioner's request. Placement thereon being without reference to compliance or non-compliance with the adopted subdivision ordinance. S 5230 MGM Plaza subdivision, major preliminary. S 5231 Rascal Commercial Subdivision, Phase 3, Major Preliminary, and S 5232 Peninsula Point Flats, previously Veterans Parkway Apartments, Major Preliminary.
I second.
All those in favor say aye.
Aye.
Opposed? That motion carries.
I move that the following rezone petitions be placed on the November 20th, 2024 Area Plan Commission public hearing agenda. Z 2942, Old Town Companies LLC, Curtis Sadison, Provenance PD Phases 3, 4, and 5, PDMX to PDRS. Z 2950, 231 Land Investors LLC, A to GB. Z 2954, Kirko LLC, A to I3. Z 2955, Arbor Homes, A to R1B, and Z 2956, Sterling 27, LLC, A to R1B.
I second.
All those in favor say aye.
Aye.
Opposed? That motion carries. Variances.
I move the following requests for variance from the Unified Zoning Ordinance are not a request for use variance prohibited by consideration by ordinance and statute. 2024-18, Weesey LLC, and 2024-19, Harold Snyder.
I second.
All those in favor say aye.
Aye.
Opposed? That motion carries. October budget report.
I move we approve the October 2024 budget report as submitted.
I second.
Okay, nothing too unusual. It's the main things are it's conference season, both the MPO conference and then the fall APA conference are landing about this time, so we're finally starting to draw down on those, on that particular item. And then we're doing some modest furniture updates in the office, drawing down on that item as we're able to. So, be happy to answer any questions.
Very good. Any questions for Ryan? Hearing none, all those in favor say aye.
Aye.
Opposed? That motion carries. Other business. We have it says rescheduling the Wednesday,
Yes,
January
so-
1. Okay.
Just wanted to ask the board here when they would like to reschedule that meeting for. Obviously, it won't be held on New Year's Day.
What would be normal, either,
The first is a Wednesday.
Should we just do it on the 8th?
the following Wednesday?
Yeah.
That would make sense to me. Anybody else have any comments on that?
Is that,
Staff would be fine with that.
Second Wednesday's got nothing
Same time.
on our end.
Just see if the room's available?
We'll make sure.
Okay. Okay.
Assume that it is. If not,
Okay,
we'll
we'll
have to
do
find an
another plan.
alternative.
Okay, January 8th then. Okay, hearing anything else? Nothing. Larry, the final.
I move we adjourn.
Okay. We are adjourned, and if we're ready, we will just go ahead and call to order the Area Plan Commission for Tippecanoe County Ordinance and Bylaw Committee for November 6th, 2024. Now, first on the agenda is approval of minutes.
I move we approve the minutes of the October 2nd, 2024 meeting.
Any comments or corrections? Hearing none, all those in favor say aye.
aye.
Opposed? That motion carries. Second, ADU, accessory dwelling units.
Afternoon, everybody. Nathan McBurnett, APC staff. round 3 here on the ADU proposed ordinance. Since last hearing, we made some amendments here. We consulted with a few of the different offices that we had outstanding questions on, mainly related to septic and well facilities in the county, requiring that they be combined between an ADU and a principal dwelling unit, and then some clarification on some of our definitions here. So a few of the offices we talked with was the county health department, the county surveyor, and then we also talked with a local soil scientist and septic installer about the septic hookups for a little bit of information about that. So the 3 points you see here on the memo are the changes that have been made since last executive committee or ordinance committee. The first one being that the initial requirement that all septic and well facilities, whether they be in the cities on public sewer and water or on well and septic, rather than all of them be combined wherever they are, we're separating that out to, if you're in the sewered area, there's a requirement to have a combined hookup between the accessory dwelling unit and the principal dwelling unit. But if you're on private well and septic, leaving that entirely up to health department review. The health department has mentioned that they would like to review that, and in many cases, it's not actually feasible that both of them be hooked up to the same facilities. The second piece that we changed is the occupancy limits for an ADU. We didn't change, but we kind of clarified this, so I'd love your feedback on whether this version of the language actually makes sense. Occupancy limits for an ADU are restricted to one family. This is exclusive of the occupants of the primary dwelling unit, meaning that the primary dwelling may also be occupied by a separate family concurrently. Just clarifying that there can be two families on the lot, basically. And then the last piece that we changed came after from feedback from Chad Spitznagel, just clarifying what would make a property eligible, and the requirement that the lot be owner-occupied. So the ADU applicant shall record a deed restriction with the county recorder, essentially saying that the property will remain owner-occupied, whether that owner of the property lives in the ADU or the principal dwelling unit. And then contingent upon approval, they also have to be eligible for a homestead tax exemption. So essentially just reaffirming those requirements that the property is in fact owner-occupied, and they would lose that homestead exemption if it's not. So that's kind of the extent of the changes we made to that second go. Happy to answer any questions.
Very good, thank you. Any immediate questions from the board? Otherwise, I'll take some public comment. Thank you. Anybody wish to speak to this from the audience? Questions or comments from the board?
You know, so obviously at the last meeting, we had some really good input from some folks, and I think I expressed my concern about our older subdivisions in the county that don't have covenants that could potentially protect them in this particular case. Because I had expressed previously that I thought this would be good to consider for the county as well. And I'm still thinking it might be good, but I'm thinking that in the county, we might want to consider just limiting that to the ag zones and to rural estates, and not in the other residential zones. But I don't know if that complicates this, or if we should do that in a separate action. Because I think West Lafayette's eager to move forward. Is that correct? So I don't want to delay that.
What's the reasoning? So
I'm not sure that it's going to work well in older subdivisions that don't have covenants. So in other words, in an R1 subdivision Most of the current ones do have covenants, and those covenants clearly state that this would not be permitted, but I'm concerned in our actual subdivisions that it may not work well.
Most
But-
of the older subdivisions that would not have covenants are probably within Lafayette city limits,
Yeah.
right? Do we have any that are in the county that
Oh,
do
yeah.
not have?
Oh, yeah. Oh, yeah.
Yeah, okay.
We have a lot.
Kathy, do you want to say something? Please.
We can change that.
Come.
We can add that easily.
Easily. So in other words, so that it would be by right in all of the residential, all of the ag, all the RE zones, or the RE zone, in all jurisdictions. Well, anyway, you can, okay. I'm eager to know if there's any feedback in regard to that. Steve, I think you spoke to this last time.
Remind me what I said. I got to tell you, quite frankly, in the members of the Builders Association, the builder group we talk to are not overly excited about ADUs. It might be more of a remodeling thing, but your point was if there's no restrictive covenants, then what happens? You can.
So I guess and I have had a handful of folks who have specifically inquired about doing this, but all of those folks were on very large
Right.
parcels
Right.
that literally wanted to put something above a garage or something like that.
Right.
And I think that works perfectly fine. So, like I said, what I'm here proposing is in the county, it would just be in the ag zones and rural estates.
Right.
So,
That seems reasonable. It seems like West Lafayette has a big interest in this, and quite frankly, I don't know where the ideal place would be. You might University Farms, but I don't think in Chauncey Hill neighborhood, those lots it'd really be difficult to, you got all kinds of issues with getting the water, sewer there, drainage. So I'm curious, if you do have a smaller lot, do you have to get a variance first for side yard setback? And then you'll have, if you get the variances, then you'll have the right to do an ADU if you're within all the setbacks, okay?
I don't think it's a variance right now, it's by right.
But if you...
Oh, I see,
if
setback
your-
variances. I
Your lot
gotcha.
coverage is a consideration, rear setbacks might be, you might want to encroach the rear setback. It might be worth trying, but I don't see a big interest from the building community that this is going to be something that's going to be a real interest.
Okay,
Anything
thank you. And now that he mentioned that, if you restrict that in the county in R1 zones, if a person had, let's say they're R1, but they have an acre lot or 2 acre lot, they'd either have to rezone, or is it possible to make that a special exception where you could hear that case, look at it, and it's not in a 10,000 square foot lot, but they're out in the country, and I'm not sure how many of those are. I was just trying to think of a path for those special situations.
Yeah, could you talk a little bit about the practicalities?
Yeah.
Because what I see is, first of all, in New Chauncey, there are structures. They're already there. They're sitting there. This allows that to be used. Whole different situation if you've got a small little lot, New Chauncey, you're not going to be able to build anything without variances, and they seem like they would be hard to get. 2 acre lot, how does that work? You come forward, say, I want to build because I want an ADU. Otherwise, without this change, it's a non-starter. You can't build 2 dwelling places on one single lot. So this gives the thumbs up to doing it. I'm not sure what else you need. Could you talk about the building? If Chad were here, I would ask him the question, but I don't know the practicality of the building code and how you get the
Well,
permitting.
the
I don't know
building
that we could
commissioner
talk
has
to that
explained
either.
to me that, when, at least in the county, when they're coming in for a building permit, they're told that they can have either a bathroom or a kitchen, but they can't have both in currently in this garage apartment or whatever it is.
Because they don't want it to be a dwelling unit.
Exactly.
Right. But now they can, because this says they can have a dwelling unit. So that advice they're being given would change.
Exactly.
The law change.
Yes. Did that answer your question or no?
I guess, because I think the answer to my question is, yeah, they can build. Because the only thing that restricted them from, or prevented them from building before, was the fact you can't have two dwelling units on one lot. You'd have to parcelize or do something to divide it. So maybe I've answered my own question, but I just wanted to make sure I was
Yes, that's
correct on
correct.
the practicalities of it.
Correct, yeah. They would not be able
Thanks.
to have done this before. And the question about maybe allowing some pathway for an R1 property, whether it's a rezone or a special exception, I think it depends on how, what kind of steps you want the property owner to go through to get this. Rezone to A would be a simpler process. They wouldn't have to speak to the use of the property under the A zone. If you're wanting to make them go through a special exception process, they would have to address all those issues like lighting, traffic, noise, and how that use is going to impact the neighbors. So it would pose a different process to get to that end goal.
Yeah. And give me your example again, Gary.
And I'm not sure without looking at the zoning map, there's always a case.
Of course, yeah.
That someone's in the county, it's zoned R1, maybe their lot's an acre, and it really would fit. So they could either rezone to A, or you could they could ask for a special exception, and they'd have a choice to do either one. Maybe they didn't want to go to A or something, I don't know. But just thinking of those special situations.
Yeah, I mean,
Yeah, I'm kind of sympathetic to the SE route, because it is site-specific, and it's possible that there may be locations where it's appropriate, the neighbors are fine, and you're also not adding other uses to the property, whereas if you go from R1 to A, there's other things you can do in A too. We may not want those, And so then we have to bring in commitments, or just keep it. They just want an Airbnb, or not an Airbnb, they want an ADU, these things. So make that singular path very clear, so.
They'd always have that choice, rezone or special exception, whatever fit their.
yeah.
Yeah, it'd still be open to them.
Right.
I know that properties that are, off the water sewer grid, we usually don't like downzoning them, so that's why my first instinct was, I'll do special exception. That's what you really want to get, is that ADU there.
Mm-hmm.
So it's just some thoughts.
Does that complicate this even further then for West Lafayette? Meaning, if one jurisdiction requires, not only is it limited in which zones in one, but also requires a special exception?
Yeah, I think there's not an interest probably within the city limits to have this. I mean, this is coming from the unincorporated county from you, so it's almost like it would need to be targeted. If it's in the unincorporated area, then you could get a special exception if you're in this zone.
Yeah, I think changing that would be a simple fix.
Yeah.
Yeah, it would be.
Sorry?
Right.
2 lines on the use table.
So it's simple, is that what you're telling me?
Correct, yeah.
Okay.
It's no different than, we have uses, in West Lafayette, in the central business West Lafayette zone, you can't have drive-throughs, but in the central business zone in Lafayette, you can, and it's 2 lines in the use table. It would be similar to that here. We would essentially have, ADUs in the county, in the unincorporated county, and then there'll be uses permitted and by special exception, and then there'll be everywhere else, so all the incorporated areas.
So one thing to consider is this is an accessory use, so it's not going to be in the permitted use table. So that kind of complicates the special exception.
So now we're amending the accessory uses chapter.
With those two, you guys want to think about that and bring it back with a solution for us?
But does West Lafayette want to move forward tonight? I mean, with your portion?
It'd be nice.
I don't want to
could.
hold up, but you've been working on it for a while, so.
What, make it West Lafayette only? Or,
And then-
or incorporated areas only?
If it's on the agenda to be heard at the APC, you think you can craft that, we'll hear it at the APC, bring us two, clean one, and then maybe Kathy can do it, I can see.
We have
Come on,
a
you
ton
got-
of
And
faith
she's
in
excited.
Kathy.
We're just trying to do it in one, or you can do it in two ordinances. It does make,
Yeah, if it
Just be
needs
west side
to, we
only,
can
or
do
one
it in two
ordinance.
if we have to.
do two, if that's the preference. What's Lafayette's?
Or send it on and you send it back.
I mean, because we're not in any huge hurry, so we
Right,
could
that's it.
just continue the county's portion until the next meeting if you wanted to.
Yeah. Yeah, there's no reason to just pass the whole thing along to every legislative body and let them deny it. Like,
Yeah.
That's just, waste of time, so.
Is Lafayette's okay with it too? So we do Lafayette, West Lafayette, and do the counties?
Well,
No,
Lafayette's not doing
Lafayette's
it.
not.
Lafayette says no.
Yeah,
Okay,
they-
so
they- yeah, they don't.
basically West Lafayette only, okay.
So we advance West Lafayette only.
I
Okay,
think that's their wish.
and then
We can do
we'll,
it.
I mean, I don't want to make this more complicated than it needs to be.
Sure.
But if we can do that, it'd be
yeah, it
nice.
started out sort of as your city's request, and other localities can jump in if they want to, or
So I
opt out,
complicated
or
it.
hold off and think about it.
No, I think you did. If you want in the county, let's,
Yeah,
All right.
yeah.
we'll look at it, so.
So we advance for West Lafayette, and then you want to continue the discussion at this
Well,
level
Can you?
for you?
Is it possible to bring something back for the next meeting that basically says?
This meeting? AOs,
yes.
Or for the OC?
Ordinance, yeah, for the ordinance meeting, that basically states it's available in R1 with special exception, and available by right in all the agricultural zones and in rural estate.
We can look into that.
Yeah.
Okay. All right, so we'll come back next month, OC, with something like that.
Okay.
All right.
Cool.
Did you say something about special exception in the R1 zone?
Yes,
Okay,
yeah.
got it. Perfect. Okay? I don't know that we need a motion, but why don't
Not
you make it?
necessarily, I think you could show by consensus, agreement of all. Pass
Are,
this on.
so is Battleground interested, or no?
I don't think that's an issue for us.
Okay.
I mean, we just don't have incorporated that many lots. We just don't know how to do it.
Okay.
Again, just don't think we could. And again, if they were to, they would have to be connected on the primary residence.
Okay.
So, sounds like by consensus, we'll forward the West Lafayette to the full Plan Commission for approval. Okay, we will do that. Nobody objects.
Thank you.
Next, terminating special exceptions. And,
Hello. So we're here tonight because 2 weeks ago, the Board of Zoning Appeals was provided with the form that you see in front of you, as well as a proposed process for the termination of an approved special exception. The ordinance and the state code are relatively silent on the special exception process as a rule, leaving it up to the jurisdictions to figure out how to approve special exceptions as well as how to terminate them. So this is our best effort at coming up with something. After that discussion at the board 2 weeks ago, they wanted to bring it to this public meeting so that they could have a chance to kind of talk it out with you all. APC has come up with a few other discussion points, as well as some from current board president Steve Clevenger. So in no particular order, things to consider. What kind of notification should be required beyond notifying the property owner? In terms of the property owner, do they have to be present at the meeting for the board to decide whether to terminate? How do we know that the owner has been properly notified? Say the certified letter comes back undeliverable. What is required in terms of that notification? If an AO or an APC staff member brings the termination, where would the sign go? Do we use the same signs that we do for special exceptions? Do we create new ones with the expectation that we have terminations? The suggestion was a detail box should be preceded by the shorter area for the ordinance or commitment they are in violation of. Would the property owner be allowed to ask for a continuance? If the termination is approved, what happens next? If we limit who can apply for one to interested persons, is the 200 feet or 2 parcels away sufficient to capture all those who might be impacted by that special exception? Do we need to establish a waiting period after the establishment of a use before the termination can be filed? Do we want to require that complaints be filed of possible zoning violations with the appropriate body before termination can be filed? And is there a process where the ABZA can add conditions or commitments to a special exception instead of termination if it would resolve that conflict? Or must a new special exception be filed so that the ABZA can add those conditions or commitments? So lots of different points to consider here. We don't have any pending requests for terminating current special exceptions, but knowing that we have received numerous complaints, we want to have this in place for when that comes.
Have we had any?
We've had complaints, but none of them have resulted in any kind of zoning violation, or if they did, they were resolved in the form of a special exception. So the ABZA wants to open it up for some discussion here, so I'll be standing by.
Thank you. So Steve is here. You have anything to fill us on? But this kind of started as just creating a form. So if that case comes, what's our procedure? Kind of creating a procedure. Don't have one? Could have one. Steve.
Sure. Thanks. Steve Clevenger, 4011 Black Forest Lane, West Lafayette, Indiana. President of the Area Board of Zoning Appeals. Some of my comments were some of the last ones dealing with the interested persons, because I know noise travels far. I mean, I can hear things that are music that's half a mile from my house. So if you have a couple intervening properties that are possibly even owned by the petitioner, are we excluding somebody that is several properties away but is still fairly close? I don't think we want to open it up to just anybody being able to file, because you can get people out of state or out of the county in order, filing these petitions. Second, some of the other ones I brought up, I don't think we want to take a termination request right after it's been approved. It could have been an illegal use. We granted approval. They really haven't had time to work it out. Do we need 6 months or a year of the use being there before we even consider termination? And then there's also, how does this fit in with the current complaint, the zoning violation, complaint process? Because we have that set up, and it seems to me that we would want something with that process to happen first before we actually consider termination of a special exception. If there's a complaint, they've been notified, and it's still an ongoing issue, then maybe we go ahead and take take action on it and hear the request. So those are just several comments I have. The last one that I had was, can the Area Board of Zoning Appeals add conditions and commitments? If it's a true zoning violation, I don't think we can do that. I mean, if it's something where they say they're saying that it's actually subverting the general purpose of the ordinance, for instance, maybe there's a condition that we can put on it, say, adjusting the hours of operation, from midnight to 11 o'clock might satisfy a neighboring property owner for noise. Just things to consider like that. And
So who's completing this form? Is it just any citizen? Or?
it's whoever we allow to complete it.
Interested party.
And interested parties.
The ordinance states specifically an interested person, the administrative officer, or APC staff can file an application.
And is that in the current?
That's
bylaws
currently,
or
it's
zoning
currently in
ordinance?
the Unified Zoning Ordinance.
Okay, that those are the people that are limited to?
Yes,
Okay.
yes.
I didn't realize that.
So is a complaining neighbor an interested party?
Yes, according to the bylaws that explain what an interested person is
Okay.
through that notification process.
And it's also any property within 200 feet?
Or two
2
parcels.
parcels away.
Is,
Those are the ones that are notified for the special exception.
do we know what other counties do in regard?
I did a very brief search of this, and there isn't a whole lot. I believe there is one other county who only allows an internal party to file this termination. They don't allow just anybody from the general public to do so. I can't recall the specifics at this point. I'm
I
sorry.
mean, and that kind of makes some sense to me,
It
especially
makes sense to me, too.
if we're going to have a new zoning enforcement officer, it should be that person, right?
Yeah.
I mean,
So the only interested person is essentially a function of government, someone, zoning enforcement officer, AO.
well, complaints can still be filed too.
Correct. And that would only entail unincorporated areas of the county, because we do approve special exceptions within city limits where we would not have been part of the complaint process or the zoning violation process. So, for example, transient guest houses within Lafayette or West Lafayette city limits would have gone through those respective AOs for the zoning enforcement. Maybe that didn't
That's a
work.
good point.
We don't know, but maybe that special exception needs to be terminated.
I would think it would be up to those AOs, though, to come forward. They would need to know that they have the right to request termination if there are
Correct.
zoning issues. So, I mean, that would actually clarify some of the issues with, who's able to file this.
Well, I would be okay
And-
with the AOs being
Yeah.
able to file it.
Yeah. And then also whether or not there's a zoning violation that's actually filed, because that would be then up to the interested part, or what we're now calling interested parties. Anybody could file a complaint with the AO or the zoning enforcement officer, and then the appropriate jurisdiction, and then it'd be up to them to decide to terminate or request termination.
That is something that, well, we've been dealing with some zoning violations that progress to the point of a lien being placed on the property. Well, property owner can pay that lien and still be in violation. But if it were a special exception, we would then have this route available to us to file the termination, so that it would be an even bigger pinch on that property owner to cease the illegal activity, whatever it might be.
Because that would allow for larger fines, or?
Not necessarily.
I mean, it's just another way to try to get compliance. Yeah, I mean, it's something we've kind of talked about internally is, what happens, if someone just pays the lien,
Right.
just persists with the violation. That's usually when I call the lawyer, say it's time to file an injunction. They're thumbing their nose at our process. And to me, that's like the final proof that, they're not serious about complying, so we have to get legal. If an AO has a choice, if the AO is the one filing the termination, or considering filing the termination, they get a complaint, this special exception's out of control. It could go the zoning enforcement route, and it probably should. They should be given a chance to clean themselves up, and we have that process in our own zoning violation process. 30, 60, 90-day fines accrue until you get to $10,000, and then we put a property lien on you. And so it seems like it should follow a similar process that before you just terminate the SE, and maybe that's it. They put the property lien on and they're still doing it, but instead of just filing suit, we just terminate the SE. But then if they're still persisting outside of the SE, well, then we're back in court. So I don't know, Eric, do you have any thoughts on this?
I think these are all great questions, and I would encourage you to think of it this way. When you grant a special exception, you have changed UZO for that specific property. So after the special exception is granted, they have laws that only cover them. So what happens when they break the law? There or any place is you have a complaint procedure. The complaint goes through the regular complaint procedure, so I would encourage you to think of it that way. You got a special law that's being violated by the people that got the special exception in the first place, so you say, wait a minute, let's go to the complaint process. The only reason this is different than anything else is because the law involving special exceptions says it may be granted by the Board of Zoning Appeals, who being the Board of Zoning Appeals, may also terminate it. You have an additional method to make the people comply. Because if that law didn't say the BZA can do a termination, you just go to court, because the judge can make them stop also. What this is an intermediate step that doesn't mean you have to file in court. Because the BZA gave it in the first place, the BZA can take it away. And if they take it away and they still ignore it, you're in court with a laydown case because you're saying, Judge, the BZA already terminated it and they refuse to comply, and the judge says, this is an easy case for me to decide. There's going to be an injunction granted, and if they violate the injunction, the judge has lots of power. So the termination has power, but if they ignore the termination, you still got to go to court. It's a good intermediate step because it's only within county government, not the court system, that allows BZA to terminate if necessary. So I would encourage you to look at it as the same as any other, and this is the direction everybody seems to be going, as any other violation. So you deal with it, hey, you got a problem, don't do this anymore. If they ignore it, then you have a choice. You can terminate, or you could go straight to court. I don't know why you'd go straight to court if you have the right before the BZA to terminate it.
So dispense
but what's the process?
with the fines and with the fines and property liens and just go right to termination.
Well, you could do the property liens also. You could do the fines also. You get this. This particular case we're talking about is no different than any other enforcement action, except you have. We could also do the BZA termination. You just give another tool in the toolbox because the BZA gave it in the first place. They can also terminate it. Don't have to go to court to do that.
What about the complaint?
Well, and that's a very good question. If you use the usual complaint procedure, all you're doing is saying, you've got a complaint, call the county government. You're going to be referred to the enforcement officer. Enforcement officer is going to take your complaint, investigate, and if it's a valid complaint, they're going to start the process. That doesn't necessarily mean that that citizen who's an interested party would necessarily be part of that process. Now, where it gets a little odd is I'm going to have to look at the state statute to see what it really says about the process and whether or not it creates that right of an interested person to complain directly to the BZA. I can't tell you that. That's what our bylaws seem to say, but we can change our own bylaws. We just can't change
It's the ordinance that says interested
Say it
person.
again.
It is the ordinance that says interested person. So
And
it
that
would
can
be
be
an
changed
ordinance.
if you choose to.
Exactly.
Because I don't see any reason to say, oh, let's change how we do everything just because it's a BZA case. To me, it's the same as anything else. It's just because they've gone to the BZA, they've gotten the approval, the law concerning their little lot has changed. They got to still follow the law as it was changed by the BZA. And if they don't, treat it the same way as you treat any violation. Don't put it on a different track. You just have another tool in your toolbox, which is to go to the BZA if you need to. You can fine them, you can put a lien on them, you can go to the BZA, you can go to court. Most of them, you don't have the BZA to help you. Just another tool.
This is only in relation to special exceptions, correct? So you could have situations, and I'll use Airbnbs as an example, where you have granted, BZA has granted special exceptions to some, but you have some out there that came before that.
They're
right?
grandfathered.
Yeah, they're
Yeah.
grandfathered. So the ones that are grandfathered, if there's a problem there, that just goes through the regular complaint system, never back to BCA. This has nothing to do with them, right?
Yeah, a grandfathered situation wouldn't be subject to the BZA.
Okay, so they still have the
As long
complaint
as they can
system.
prove grandfathering. Yeah.
Yeah.
That would have to be established through the AO.
They really wouldn't have a complaint because, the zoning enforcement officer can't do anything because they're grandfathered. Other than if they were,
Yeah,
Let's say
for the
they stopped
use.
using it for a year,
Yeah,
Yeah.
which you lose the grandfather.
right. If they're getting noisy or something like that,
They could call the
that's
sheriff or-
municipal code.
Yeah.
Yeah, the cops will take care of that.
Okay.
Yeah.
Okay.
So we've got options, Eric.
We have options. And you don't always have to go to the lawyer, which is sad but true.
Do you have an opinion on this? Yeah.
I guess, to me, it sounds like we need to make a decision first whether or not an interested party can file a termination. And that portion of the ordinance, if we want the interested party to be able to file a termination, then we can go ahead and decide on what changes we want to make to the BZA bylaws.
the only thing I would be,
Otherwise, we'd have to change the zoning ordinance first,
yeah,
and then we could do what we wanted with the procedure for the termination.
I would be concerned that you would have disgruntled neighbors
Yes.
that would
And
be
that's-
filing these every single month,
Yeah.
and that's all you'll be doing at your
Yeah.
meeting.
And that's one of the reasons why I said, do we need a grace period, and do we need a complaint actually a new complaint that has been filed, rather than the same complaint being filed over and over.
Yeah. In this case, I think we should consider a revision to the ordinance that states that this would have to be completed by the AO or.
And,
So
that sounds very reasonable, and I'm fine with that as well.
So it would be.
Here.
Got one right here. So it would just be, Tom, you're envisioning that the AO has to make the judgment call. They'll receive X number of complaints, or perhaps just one, and then the AO gets to decide, which would be appropriate. They're the interpreter of the ordinance, essentially, the first line, whether it rises to the level of, yeah, I've had too many of these complaints, we're done, files a termination, or makes the judgment call, first-time offender, let's do the friendly letter, see if we can sort this out neighborly.
Yep.
But either way, the AO gets to decide the path.
Yeah.
Okay. That's clear. That could be, the ordinance could be amended to make that crystal clear.
So
I would like to say that, that sounds, very reasonable to me to go that method, and I think it's, one approach then, as opposed to, multiple attacks on, a special exception.
Essentially if there are those sorts of complainers, they can attack the AO with their complaints, yes.
Question
And
for,
I know Gary's on the board, Ed's on the board, I don't know if they have any
so,
comments as well.
question for Eric or staff. We're really not adding any powers that aren't already there. We just started to get a form and try to set a procedure, so when that, if that case comes, we kind of have a procedure where we don't have to figure it out on the fly. So we're really not doing
Correct.
anything that's by
This-
law not
Yeah,
already
Kathy
there.
just said it, it's been on the books for a long time.
Yes.
It's just, no, we've never advertised that we can do this. No one's ever looked it up and said, hey, I want to do that.
It's been, we resolve those issues before it gets that far.
But
So
in the event
far-
a citizen says, is there a way that we can terminate this thing? Then we're on the spot to say, well, yes.
No, you can't, but the AO can, is what I'm kind of agreeing, that the AO
Right.
should be the person, if it gets to that case.
Right. Did you have something you wanted to add?
No.
Okay. So we're looking at, I think, a spot UZO amendment to make it clear that it is the AO that initiates termination.
Yeah, as long as, and I'll look into it, I've been trying to research it on my phone, which isn't my best foot forward, but anyway, just making sure that the state statute does not say that in the event of BZA grants one that is going to be terminated, that interested parties shall have the right to enforce.
Okay.
I don't think it says that.
So
It's
you'll
our
get back to
bylaws
us.
that say that. We can change our bylaws, we can change our own rule, we can't change state code. So as long as state code says what I expect it to say, sure, we can
Okay.
do exactly as we've just discussed.
Then we'll stand by to hear back from you on that
I'll
point.
keep looking.
Right, we'll just put, well, just,
You
I'd
need
say
a
we just-
pad, not a phone.
I know.
I'd say we just hear it next month, so.
The other thing I would suggest is part of the reason that it came here is that the Board of Zoning Appeals, I think correctly, did not want to start taking public input at a BZA meeting, because that's not the purpose. It's a quasi-judicial body that only listens to the cases, not public
Right.
discussion of it. So it may be you want to see if there's anybody in the audience that wants to
Thank
have
you.
input.
Any
Maybe your
public
call.
input from anybody that's in the audience? Thank you.
Terrence Elser, 5203 East 550 South. I don't know if I really have any input at this point. I'm just trying to follow this process along and see what our options are in the future. So we've been filing the complaints, and maybe I am a disgruntled neighbor somewhat, but this agricultural rental hall was approved, and we are not even 1,000 feet away from it, which is the issue that's going on. And they've been grandfathered in because it wasn't actually in writing until they already had their special exemption. So that's why I'm kind of curious at how things are going to go here, and I'll follow whatever process you guys see fit,
Because you'd still have the means to file complaints, it would just be through the AO.
which we are, and
Yeah.
our complaints don't seem to get anywhere, really. When they first opened, a year or two after they opened, we had gathered up several different complaints. We filed it, and they got a letter that was not official, an unofficial warning, if you will. And since then, things have just escalated. We're too close to them, they're too close to us, and we interfere with each other's lives, so.
Okay, so we're just trying to, hopefully they can resolve that, but if it gets where they will not comply, that's where the AO could, we'll have a procedure, like we said, it's always been there, but there's really not been a discussion or a path for.
Okay, and also, I mean, their hours of operation have changed from one exception to another exception when it says that they're going to remain the same, but it's wrote differently.
I'm going to say, we can't hear that case.
I
mean,
understand,
staff
I
can help
understand.
you
I'm
with
just,
that.
I'm
Different
just saying,
body.
I'm just saying that things aren't, that's part of our complaint process. And things aren't getting settled the way we think they should be settled. So I'll follow this, and thank you guys for your time.
Okay. Thank you. So what I hear, anyone else wish to address this? Steve?
Can I say something?
Sure.
Just to let you know, part of that is that you guys changed the ordinance so that, and increased the setback that is required, and that's part of what he's talking about. So that, I mean, that part's not in violation or whatever, but I'm gonna stay out of the case. There was another point I was gonna make, and it's kind of left. But I think of it, I'll come back
Okay, just
up.
come back up. Ed, you got anything to add? Nope, okay, Ed's also on the BZA. So what I hear is we're looking at approving a form, being able to be initiated by the AO. Eric's going to look up statute, and I'd say we just hear it back next meeting. Unless anyone else has something to add, Steve has something for us.
That was what I was going to say. One of the questions we get at the Board of Zoning Appeals is that a lot of these violations, whether it be a party or something at a Airbnb or something at one of these agricultural rental halls, is that they happen in the evening or at night, not during the day. And who is going to actually go out and try and gather information? I don't know if somebody like this new zoning enforcement person would be able to possibly be able to address complaints or go out and actually, when they have events at these, be able to, how do you actually gather evidence that they're in violation besides people just gathering evidence and then you take their word against the petitioner's word?
Good point.
Yeah.
Anything else on this issue? It sounds like we'll just hear that again next month. Hopefully we'll have a little clearer direction. So, seemed simple at the time to make a form, but
It sure did.
yeah, I'll just approve this form. So, air it out. Any other comments on this? If not, we'll just hear that again. Thank you. Citizens' comments or grievances? I guess this is just comments. Hearing none, we'll take that last motion.
I move we adjourn.
Okay, adjourn.
Yeah, that is one of those that...
That'd be great. I'm assuming that you'll have